demonetization of rupees 500 and rupees 1000 notes on November 8th, 2016. This was the most discussed topic by many people in India. Not only India but also in other countries. The Honorable Supreme Court has upheld the central government's decision to cancel rupees 500 and rupees 1000 currency notes at 4 hours notice on November 8, 2016. A 5-member constitution bench decided that no flaws in the decision-making process in the ruling of the Honorable Supreme Court. It can't be said there was no conscious, effective, meaningful and purposeful consultation between the government and the Reserve Bank of India before demonetization. This is the opinion expressed by the Honorable Supreme Court about the demonetization call given in 2016. The majority judgment said that the 2016 notification of demonetization satisfies the test of proportionality. The period of 52 days provided for exchange of notes while the notification cannot be said to be unreasonable. Even the number of days given to exchange the notes also not considered as unreasonable. The matter of demonetization was under active consideration for 6 months between Reserve Bank of India and the central government. Before announcing the demonetization call, both the central government and the Reserve Bank of India were carrying on active consultation about the notification call of demonetization. As such, merely because the central government has advised the Reserve Bank of India Central Board to consider recommending demonetization, and that the Central Board, on the advice of the central government, has considered the proposal for demonetization and recommended it, and thereafter the government has taken a decision, in our view, cannot be a ground to hold that the procedure prescribed under Section 26 of the Reserve Bank of India was breached. Means, according to the judgment delivered by the Honorable Supreme Court, the provisions of Section 26 of the Reserve Bank of India were not breached when the Reserve Bank has recommended the demonetization to consider and also the central government has considered the proposal of demonetization. Both the Central Board of Reserve Bank of India, while making recommendation, and the government, while taking the decision, have been taken into consideration all the relevant factors. It means both the Reserve Bank of India, both the regulator, Reserve Bank of India and the central government has taken every factor into consideration before announcing the demonetization call in 2016. Of course, there was a lot of inconvenience caused to many people, especially small and middle class people, to exchange their notes of 500 or 1000 notes against the new notes. Sometimes the earlier, initially only 2000 notes were disbursed to the consumers through banks, but the amount was not sufficient to meet the expectations, to meet the demand from Indians. For nearly 1 week to 10 days, there was a lot of disturbance and long queues before the banks and post offices to exchange their 500 and 1000 notes against the new currency of rupees 200 and 500 notes. During that process of long queues and crowds gathering, there was some loss of human life also, and there was a lot of inconvenience caused to the especially to the poor and middle class people, and also small traders in exchanging their notes and to carry on financial activities to receive the payments, to make the payments, and that was a lot of inconvenience caused to the many people of India. Of course, the transfer of funds from one bank account to other bank account or non-cash transactions were not affected, but the actually cash delivery or cash payments were highly disturbed, and there was a lot of inconvenience. Earlier, there were no digital payment platforms available to citizens as available today. That was a lot of during the year after announcing demonetization in 2016. There is a lot of inconvenience caused to not only small people, especially farmers, small traders, street vendors, MSME, and every small people, middle class people have affected first to carry on the business and to exchange the notes. It was a lot of inconvenience, lot of trouble was there, lot of trouble faced by many citizens of India. Of course, after some time, means after 52 days, the new currency came into the new currency with 500 rupees and 2000 rupees notes came into market, and thus the problems of the people has been reduced, especially not by the new 500 and 2000 rupees notes, but with the availability of digital payment platforms, especially UPI, and all these payments and have made available to even small vendors. Everyone is using the digital payments technology to receive the payments as well as to make the payments. The digital payments not only helped B2C but also B2B also helped in transferring the funds from one person to one trader to other trader, one trader to consumer, from consumer to traders also. There was a lot of discussion about the legality and the legality of the procedure adopted by the central government in declaring demonetization call in 2016 with the decision, with the judgment of the Honorable Supreme Court that which upheld the action, central government decision to cancel rupees 500 and rupees 1000 currency notes and granting a 52 days for exchange of new old notes with demonetized notes with new notes was also felt valid, and about with regarding the legal process, administrative process, and considerations and general consideration all have been considered, have been upheld by the Reserve Bank, by the Honorable Supreme Court judgment. There was a perfect, as per the Honorable Supreme Court observation, there was a perfect coordination between the central government and the Central Board of Reserve Bank of India before, and due process, due discussion, deliberations, the needed deliberations were carried on between the Reserve Bank of India and the central government before announcing the demonetization call in 2016. The materiality, the legality, and also purpose of the demonetization was also upheld. Of course, the outcome may not be as expected, but the purpose was not disputed, but not negated by the Honorable Supreme Court. The recommendations of the Reserve Bank of India to announce the demonetization by the central government was the process considered as valid and as per the provisions of the Reserve Bank of India Act. There is no, as per the Honorable Supreme Court judgment, there was no violation. Any provisions of Reserve Bank of India as well as the procedure are adopted by the central government of India in declaration of demonetization on November 8, 2016. With this, with the Honorable Supreme Court judgment in the case of demonetization declaration in 2016, upheld, confirms the legality, validity, purpose, as well as the coordination between the central government and the Reserve Bank of India, and perfect coordination was exhibited. Of course, there were some issues. There were some issues in disbursing, in exchange of notes. Also, there was a lot of issue because only rupees 4,000 was allowed to be withdrawn, and the balance was to be not allowed to be withdrawn, and only small amount was allowed to be withdrawn. That caused a lot of inconvenience to many small people, especially day wage earners and middle class small traders, and small people were affected much. Now, because of the availability of digital payment platforms, digital transactions, financial transactions carried on even with small amounts, and that is causing a lot of help to increase the volume of transactions, and also reducing the usage of actual cash in carrying on the activities or B2B as well as B2C. This is the procedure adopted by the Reserve Bank, by the central government in declaring the demonetization 2016 was upheld by the Honorable Supreme Court through its judgment on the demonetization call given by the central government in 2016.